And, as the court has stated, the goal of preventing abortion does not constitute invidiously discriminatory animus against women. Bray v. Alexandria Women's Health Clinic, 1993. Accordingly, laws regulating or prohibiting abortion are not subject to heightened scrutiny. Rather, they are governed by the same standard of review as other health and safety measures. With this new theory addressed, we turn to Casey's bold assertion that the abortion right is an aspect of the liberty protected by the Due Process Clause of the 14th Amendment. The underlying theory on which this argument rests that the 14th Amendment's Due Process Clause provides substantive as well as procedural protection for liberty has long been controversial. But our decisions have held that the Due Process Clause protects two categories of substantive rights. The first consists of rights guaranteed by the first 8 amendments. Those amendments originally applied only to the federal government. Tiernan v. Mayor of Baltimore, 1833, opinion of Marshall, C.J. But this court has held that the Due Process Clause of the 14th Amendment incorporates the great majority of those rights and thus makes them equally applicable to the states. The second category, which is the one in question here, comprises a select list of fundamental rights that are not mentioned anywhere in the Constitution. In deciding whether a right falls into either of these categories, the court has long asked whether the right is deeply rooted in our history and tradition, and whether it is essential to our nation's scheme of ordered liberty, ring in part and concurring in the judgment. Surveying history and reaching the same result under 14th Amendment's Privileges or Immunities Clause. Timms and MacDonald concerned the question whether the 14th Amendment protects rights that are expressly set out in the Bill of Rights. And it would be anomalous if similar historical support were not required when a putative right is not mentioned anywhere in the Constitution. Thus, in Glucksberg, which held that the Due Process Clause does not confer a right to assisted suicide, the court surveyed more than 700 years of Anglo-American common law tradition, and made clear that a fundamental right must be objectively deeply rooted in this nation's history and tradition. Historical inquiries of this nature are essential whenever we are asked to recognize a new component of the liberty protected by the Due Process Clause, because the term liberty alone provides little guidance. Liberty is a capacious term. As Lincoln once said, we all declare for liberty, but in using the same word we do not all mean the same thing. In a well-known essay, Isaiah Berlin reported that historians of ideas had catalogued more than 200 different senses in which the terms had been used in interpreting what is meant by the 14th Amendment's reference to liberty. We must guard against the natural human tendency to confuse what that amendment protects with our own ardent views about the liberty that Americans should enjoy. That is why the court has long been reluctant to recognize rights that are not mentioned in the Constitution. Collins v. Harker Heights, 1992. Substantive due process has at times been a treacherous field for this court. Moore v. East Cleveland, 1977, plurality opinion. And it has sometimes led the court to usurp authority that the Constitution entrusts to the people's elected representatives. Secretary Regents of University of Michigan v. Ewing, 1985. As the court cautioned in Glucksberg, we must exercise the utmost care whenever we are asked to break new ground in this field, lest the liberty protected by the Due Process Clause be subtly transformed into the policy preferences of the members of this court. On occasion, when the court has ignored the appropriate limits imposed by respect for the teachings of history, it has fallen into the freewheeling judicial policy-making that characterized discredited decisions such as Lochner v. New York, 1905. The court must not fall prey to such an unprincipled approach. Instead, guided by the history and tradition that map the essential components of our nation's concept of ordered liberty, we must ask what the 14th Amendment means by the term liberty. When we engage in that inquiry in the present case, the clear answer is that the 14th Amendment does not protect the right to an abortion. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. Zero. None. No state constitutional provision had recognized such a right, until a few years before Roe was handed down. No federal or state court had recognized such a right, nor had any scholarly treatise of which we are aware. And although law review articles are not reticent about advocating new rights, the earliest article proposing a constitutional right to abortion that has come to our attention was published only a few years before Roe. Not only was there no support for such a constitutional right until shortly before Roe, but abortion had long been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. By the time of the adoption of the 14th Amendment, 3/4 of the states had made abortion a crime at any stage of pregnancy, and the remaining states would soon follow. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. It is therefore important to set the record straight. We begin with the common law, under which abortion was a crime at least after quickening, i.e., the first felt movement of the fetus in the womb, which usually occurs between the 16th and 18th week of pregnancy. The eminent common law authorities, Blackstone, Koch, Hale, and the like, Collar v. Kansas, 2020. All describe abortion after quickening as criminal. Henry de Bracton's 13th century treatise explained that if a person has struck a pregnant woman, or has given her poison, whereby he has caused an abortion, if the fetus be already formed and animated, and particularly if it be animated, he commits homicide. Sir Edward Coke's 17th century treatise likewise asserted that abortion of a quick child was murder if the child be born alive, and a great misprision if the child dieth in her body. Misprision referred to some heinous offence under the degree of felony. Two treatises by Sir Matthew Hale likewise described abortion of a quick child who died in the womb as a great crime and a great misprision, and writing near the time of the adoption of our Constitution. Blackstone explained that abortion of a quick child was, by the ancient law, homicide or manslaughter, citing Bracton, and at least a very heinous misdemeanor, citing Koch. English cases dating all the way back to the 13th century corroborate the treatise's statements that abortion was a crime. In 1732, for example, Eleanor Bayer was convicted of destroying the fetus in the womb of another woman and thereby causing her to miscarry. For that crime and another misdemeanor, Bayer was sentenced to 2 days in the pillory and 3 years imprisonment. Although a pre-quickening abortion was not itself considered homicide, it does not follow that abortion was permissible at common law, much less that abortion was a legal right. Removal of common law's harsh sanctions did not represent an acceptance of suicide. Quite to the contrary. In the 1732 case mentioned above, the judge said of the charge of abortion, with no mention of quickening, that he had never met with a case so barbarous and unnatural. Similarly, an indictment from 1602, which did not distinguish between a pre-quickening and post-quickening abortion, described abortion as pernicious and against the peace of Our Lady the Queen, her crown and dignity. That the common law did not condone even pre-quickening abortions is confirmed by what one might call a proto-felony murder rule. Hale and Blackstone explained a way in which a pre-quickening abortion could rise to the level of a homicide. Hale wrote that if a physician gave a woman with child a potion to cause an abortion, and the woman died, it was murder because the potion was given unlawfully to destroy her child within her. As Blackstone explained, to be murder or killing had to be done with malice aforethought, either express or implied. In the case of an abortionist, Blackstone wrote, the law will imply malice, for the same reason that it would imply malice if a person who intended to kill one person accidentally killed a different person, if one shoots at A and misses him, but kills B. This is murder, because of the previous felonious intent, which the law transfers from one to the other. The same is the case, where one lays poison for A, and B, against whom the prisoner had no malicious intent, takes it, and it kills him. This is likewise murder. So also if one gives a woman with child a medicine to procure abortion, and it operates so violently as to kill the woman, this is murder in the person who gave it. Notably, Blackstone, like Hale, did not state that this proto-felony murder rule required that the woman be with quick child, only that she be with child. And it is revealing that Hale and Blackstone treated abortionists differently from other physicians or surgeons who caused the death of a patient without any intent of doing the patient any bodily hurt. These other physicians, even if unlicensed, would not be guilty of murder or manslaughter. But a physician performing an abortion would, precisely because his aim was an unlawful one. Although common law authorities differed on the severity of punishment for abortions committed at different points in pregnancy, none endorsed the practice. Moreover, we are aware of no common law case or authority, and the parties have not pointed to any, that remotely suggests a positive right to procure an abortion at any stage of pregnancy. In this country, the historical record is similar. The most important early American edition of Blackstone's Commentaries, District of Columbia v. Heller, 2008. Reported Blackstone's statement that abortion of a quick child was at least a heinous misdemeanor, and that edition also included Blackstone's discussion of the proto-felony murder rule. Manuals for justices of the peace printed in colonies in the 18th century typically restated the common law rule on abortion. And some manuals repeated Hale's and Blackstone's statements that anyone who prescribed medication unlawfully to destroy the child would be guilty of murder if the woman died. The few cases available from the early colonial period corroborate that abortion was a crime. In Maryland in 1652, for example, an indictment charged that a man murderously endeavored to destroy or murder the child by him begotten in the womb. And by the 19th century, courts frequently explained that the common law made abortion of a quick child a crime. The original ground for drawing a distinction between pre- and post-quickening abortions is not entirely clear. But some have attributed the rule to the difficulty of proving that a pre-quickening fetus was alive. At that time, there were no scientific methods for detecting pregnancy in its early stages, and thus, as one court put it in 1872, until the period of quickening there is no evidence of life, and whatever may be said of the fetus. The law has fixed upon this period of gestation as the time when the child is endowed with life because fetal movements are the first clearly marked and well-defined evidences of life. Evans v.S. People. N.Y., 1872, State v. Cooper, 1849, in contemplation of law, life commences at the moment of quickening, at the moment when the embryo gives the first physical proof of life. No matter when it first received it. The Solicitor General offers a different explanation of the basis for the quickening rule, namely, that before quickening the common law did not regard a fetus as having a separate and independent existence. Brief for United States as Amicus Curiae 26, quoting Commonwealth v. Parker. Massachusetts, 1818. But the case on which the Solicitor General relies for this proposition also suggested that the criminal law's quickening rule was out of step with the treatment of prenatal life in other areas of law, noting that to many purposes, in reference to civil rights, an infant in ventre s'aimere is regarded as a person in being. At any rate, the original ground for the quickening rule is of little importance for present purposes because the rule was abandoned in the 19th century. During that period, treatise writers and commentators criticized the quickening distinction as neither in accordance with the result of medical experience, nor with the principles of the common law, describing the quickening distinction as absurd and injurious. In 1803, the British Parliament made abortion a crime at all stages of pregnancy and authorized the imposition of severe punishment. One scholar has suggested that Parliament's decision may partly have been attributable to the medical man's concern that fetal life should be protected by the law at all stages of gestation. In this country during the 19th century, the vast majority of the states enacted statutes criminalizing abortion at all stages of pregnancy. By 1868, when the 14th Amendment was ratified, 3/4 of the states, 28 out of 37, had enacted statutes making abortion a crime even if it was performed before quickening. Of the 9 states that had not yet criminalized abortion at all stages, all but one did so by 1910. The trend in the territories that would become the last 13 states was similar. All of them criminalized abortion at all stages of pregnancy between 1850, the Kingdom of Hawaii, and 1919, New Mexico. By the end of the 1950s, according to the Roe Court's own count, statutes in all but 4 states and the District of Columbia prohibited abortion, however and whenever performed, unless done to save or preserve the life of the mother. This overwhelming consensus endured until the day Roe was decided. At that time, also by the Roe Court's own count, a substantial majority 30 states still prohibited abortion at all stages except to save the life of the mother. And though Roe discerned a trend toward liberalization in about 1/3 of the states, those states still criminalized some abortions and regulated them more stringently than Roe would allow. In short, the court's opinion in Roe itself convincingly refutes the notion that the abortion liberty is deeply rooted in the history or tradition of our people. The inescapable conclusion is that a right to abortion is not deeply rooted in the nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973.